Hello everyone, welcome to the show, The Focus Line. Today we are going to discuss the many articles which came in the Hindu. They are very crucial from the perspective of the mains as well as the prelims. So many of the articles belongs to GS2 and GS3. One article will see it from the GS4, that is ethics perspective. So to in today's session we are going to see these articles. The primary articles, these are the GS2, where we are saying about the concealing the judge dissent, eroding judicial authority. Nothing but is talking about the collegium system. So we'll discuss the collegium system. We'll discuss from the men's perspective particularly. Then there is a GST Council approve the uh, two rates slab structure. There is spelling mistake here. Then GS3, the foreign companies halted India's project worth of 2 lakh crore in the quarter 1. So this also we are going to discuss from the men's perspective. Then third article is there. How can the friendship be proven? Documentary evidence for the organ donation. We are going to see the act related to organ donation. And last is about the one is about the new port bill. So that also we are going to discuss. And one more article that came in explained series of the Hindu talks of the should reservation exceed the 50% ceiling. So these all article we are going to discuss from the particularly men's perspective. So when we'll start the discussion, the first article is about the this collegium system, and the context is that you are aware about the yesterday only while discussing I gave the example. The Justice B.V. Nagaratna, he well dissent. He dissented the appointment, the recommendation of appointment of Justice Vipul Pancholi to the Supreme Court. And also the problem is that what opinion she rendered under this particular dissent, that is not in the not made in the public. So that is the one more drawback of the collegium system. So what we are saying, we are going to see what is the problem with this current system, that is the collegium system. So before going starting discussion, we'll briefly see what is the history of collegium system. You all are aware. To just bring flow in our discussion, we'll start from the this particularly how the collegium system evolved. So if you are aware about the Supreme Court, that according to Constitution, the article 124, it gives power to President of India to appoint judges of Supreme Court, and this is the President is the sole authority on this on when it comes to the appointment of judges, and when it comes to the appointment of other judges than the Chief Justice of India, then President need to take the recommendation from the Chief Justice of India, and this particular the provision becomes very critical, and through this provision only the collegium system evolved. So it all started in 1981. So this popularly known as first judge case. So in this first judge case, what happened? The recommendation of the Chief Justice of India to the President, so it is not obligatory. So the recommendatory nature under Article 124, the recommendations are not obligatory. So the President can consider the opinion of Chief Justice, but ultimately he or she can act on their own opinion. So this is the happened in first judge case. Then comes the second judge case in 1991. Sorry, the first judge case happened in 1983. So 1991, the second judge case comes. So in second judge case, what Supreme Court says, the opinion or the recommendation given by the Chief Justice to the President of India, it is binding. So the opinion or recommendation given by the Supreme Court to the President of India is the binding, and for this they suggested Chief Justice of India should consult two senior most judges. So this happened in second judge case, and here actual the present nature of the collegium system starting evolving. So then comes the third judge case in 1998. So in this third judge case, what Supreme Court says, they keep their previous opinion that this the recommendation or binding. So still recommendations are binding. Just Chief Justice of India need to consult with the four senior most judges of the Supreme Court. And also there is one take that given, if just Chief Justice of India is not consulted with the four senior most judges, or out of the four, two judges given the the opposite opinion, then the recommendation given by Chief Justice of India to the President will not be binding on the President. So this is the happened in third judge's case. And the fourth judge case, that is popularly known as NJIC case, where the government came with 99th constitutional amendment, where they brought the National Judiciary Appointment Commission, and this particular case known as, in 2014, it is known as fourth judge's case. So where the Supreme Court says the present working of collegium system will prevail over the NJC. So Supreme Court says that the NJC that's recommended by government will not be taken forward. So whatever the present process is there, that will be taken the forward. So this is all about the evolution of collegium system. Then now we'll see what is exactly happening with collegium system. What are the issues related to? First, the issue is that judges appointing judges. So judges appointing judges, what is happening? There are two issues. First is what is leading to self-selecting elites. So judges are selecting judges on their own consideration. Second, it is against the separation of power. So what Constitution says, whenever there is certain decision would be taken, there should be separation of power, and the judges themselves are appointing judges, so it is against the separation of power. Second issue, the opacity is in collegium system. So if you see the collegium system, they often show anonymity. Okay, so whenever the collegium resolution comes regarding appointment or the rejecting the opinion of government, there would be anonymity. So the actual dissents, they will tell this person or these judges has pinned their dissent for this particular decision, but they will not disclose. So what exactly on what criteria they will pin their dissent, that will not be disclosed in the public forum. So that is the one more case. Next is the lack of accountability. When it comes to lack of accountability, judicial objection. If judiciary objects something, if the government wants to appoint certain judge on some merit basis or other basis, then judiciary, if objecting, then there is no reason. Okay, because there is no reason in the sense, if politicians or executive is objecting certain thing, then people have the capacity to ask for the reason through the election or anywhere, any other means. But when it comes to the judiciary, there is no such mechanism where the people can ask the judges to give the reasons. So that is the one more case, one more issue. Then again, it is the weak democracy signal, because the candidate who are not appointed. So if you see the recent cases where the 84 names taken on the table, but out of the 84, only the 5 or 6 were recommended for the position. So the what names remain unnamed. Okay, and on what criteria they not recommended for the position, that will be not given to the public, or that will not be disclosed into public domain. So that is the one more case here. Also, it endangers the secrecy. So how it endangers secrecy? Because the judges appointing judges, and there would be a problem of transparency. What actually it leads? It will lead to erode the judicial authority. Also, it make the impression of arbitrariness. So even the last time we have seen their government rejected certain recommendation, that time again the Supreme Court given the same name. So there is the impression of arbitrariness. Also, it reduced trust in judiciary's independence, because they are not working as an independent institute, but there might be some impact. This personal vested interest might be influence this one. And how it will influence? There is the cases where the close kins or relatives of judges working in the same high court. So there are the numerous cases on this. So that's why there is question on independence of judiciary also. So these are all the issue created by the collegium system itself. So if we want to reform the collegium system, there need to certain criteria where we can reform. So what would be way forward? So there is need of transparency in appointment. How transparency will be brought in appointment? There should be public disclosure of reasons. Judges are recommending certain judges for the office. there need to be give the certain reason why they are recommending or why they are not recommending certain person. So there is one practice in the presidential secretariat where they have established presidential communique, and this particularly done by the former president K.R. Narayan. So on that line, there should be Supreme Court communique where the judges can be, the Supreme Court can come with the reasons behind the what they are not appointing. So this one can be done. Here again, there need of institutional reform in collegium. How these institutional reforms will be brought? It will be brought by the establishment of NJC, that is National Judicial Appointment Commission, and there should be primacy to the Chief Justice of India, but not supremacy. So what we need to ensure, there should be adequate separation of power should be preserved when they will establish the NJC. Next reform that there need to be strengthened accountability. So it will happen through the communication, same way, by appointing the Supreme Court communique. Okay, through this reform needs into judiciary to make the collegium, the appointment procedure, more transparent and accountable to the people. So we'll move towards the next article. So we'll move towards the next article. It is about the GST Council approves the two-rate tax slab effective from the September 22. Actually, we have discussed this article in weekly focus line of that happened in Saturday, last Saturday only. Here I have discussed. I will give the just brief idea what is happening here. So currently the GST system, if you see, so currently GST system, there are the 4 slabs. What are the 4 slabs? 4 slabs are 5%, 12%, 18%, and 28%. So now why we need these 2 slabs? If you see the reason, what is happening currently? So currently this slab, particularly this 18% slab, it gives the 65% of the total revenue. Whatever revenue we collect from through the GST, all about the 65% come from this 18% slab, and these all slabs are remaining slabs are negligible when it comes to the tax collection. So considering this, what government is doing, they are coming with only 2 slabs. So what would be 2 slabs? Instead of this 4 slab, there would be now 2 slabs. Okay, the 2 slabs that our government recommended, that would be 5% and 80%. And in addition to this, there would be one more slab of the 40%, and this majority or the priority is brought to the ensure the state autonomy in the revenue collection, because this 40% slab will be, this 40% rate will be imposed on the goods such as tobacco, luxury items. So the cess coming for the state that can be come from this 40%. Also there will be revenue for the government, and the losses that happening because of the abolition of 28% and 12%, that can be covered. So if you see these 2 aspects, there are the 2 reasons, 2 reforms that we can bring through the 2 slabs. First is the rationalizing GST. Second is the ease of doing business and the ease of living. So how it will be rationalized GST? Because you see if there are 4 slabs, what will lead? It will lead to administrative inefficiency. So if you see the only 80% is contributing 65%, other remaining 3 are contributing around the 35%. So what is happening here? To collect whatever the administrative efforts need to put on the other 3 slabs that are equal to the third one. So it is reducing the administrative efficiency, and reducing the 4 slab to 2 slab, what will happen? It will increase the administrative efficiency. And what will again, second thing will happen, it will take us to the revenue neutral rate. So revenue neutral rate means there would be one rate for the all product. This currently is in function in the Australia and the New Zealand. So we are moving towards that particular aspect. And second, when it comes to ease of doing business, because there would be less compliance burden on the this consumers as well as the business person, because they need to either align with this 5% slab or the 18% slab. So there would be ease of doing business. And when it comes to ease of living, how it will increase the ease of living? If you see this chart where the government has came with where they will reduce the tax rate. So now the hair oil, shampoo, toothpaste, which previously they used to charge 80%, now it came down to 5%. Okay, so what will happen? The daily necessary things which are essential nowadays, that will be reduced. The tax rate would be reduced. Okay, so they will have the more saving. The households will have the more saving. So again, if you see the study material, there also they have literally removed all the tax slab on the map, charts, globes. Also, when it comes to the electronic appliances like air conditioning, television, all these things, now the slab which had previously had the 28%, it came to 18%. Now, if you see the India's growing middle class, what is happening? Middle class is the pro consumer. So they are focusing on the life standard. So they will be focusing on this AC, other electric appliances, electric or electronic appliances. So now if you reduce the taxes, then what will happen? It will directly benefit this middle class. So middle class will be in profit, because through they're increasing saving, and the saving is increasing means what? It will lead to more expenditure, and more expenditure in the sense GDP growth. So nowadays we know the middle class is the it's the engine of the growth of the country, and through this tax reduction we can ensure there will be proper GDP growth maintained, and some benefits will be given to the middle class also. This is all you need to know about this particular article. Also, I have discussed in detail why we need GST reform, what are the issues related to GST in Saturday's session. That session you can see to get more clarity. So next article is about the foreign companies halted India's project worth of 2 lakh crore in quarter 1. So why this is very concerning? Because if you see the data, so it is nearly 2 lakh crore in quarter 1, but it is the 1200% higher than the quarter 1 of last year. So this is very concerning. Also, it highest since the 2010, when the government started in 2010 itself. Government started releasing the data on the this foreign companies investment into project. So from that time, this is the highest one. So that 2 lakh crore the pulled by the foreign companies. Also, it is higher than the long term quarterly average. And how much higher? It is the 570%. That's why if you see the data, that's why it is very concerning. And why it is concerning, that we will see in discuss, and just we will briefly see why these projects got dropped because of the some projects dropped because they abandoned entirely, like foreign companies are no more interested to invest or do business here. Second is the shell temporarily. So due to tariff measures imposed by the USA and other things, they have temporarily closed. Some are stalled because might be bureaucratic delay, or also the reforms needed in the labor law, tax law, other that issue would be there. And majority are in the lack of information. So there is a problem of issue of transparency, because many of the projects which are where the foreign companies pooled their investment, that categorized under lack of informations. Okay, so there is again the transparency. Now we will see why these projects are dropped. So when you start seeing why the projects are dropped, the first important the immediate reason is the tariff related uncertainty. Okay, so tariff related uncertainty, why is the biggest factor? Because what is happening, there is no stable market now. If tariff continued for the long time, what will exactly happen? There will be high rate, high cost. They want to sell the product to USA. Also, if the high cost is there, then what will happen? It will reduce their profit margin. So due to these aspects, and this caused by the tariff uncertainty. Okay, so this is the immediate and major reason. Also, there is a global slowdown pressure. Okay, so foreign companies are interested in consolidating their investments, and they are trying to go towards the where the tariff rates are low, and the which countries are ensuring the stable growth rate. So they are consolidating investment. Also, there are domestic factors, domestic regulatory bottleneck. Just I was discussing related to India's delay in land acquisition. Okay, that is the one issue. Also, the policy clearance, due to bureaucratic hurdle. Also, taxation related because there is less clearance, clarity. Also, labor reforms are pending. There is concern when it comes to the IPR regime. So, all these domestic bottleneck leading to what the it is impacting the foreign direct investment in India. Also, there is lack of predictable trade and investment environment. So if you see, the government has came with a new foreign export policy, export policy. But if you see, there is a confusion when it comes to the now. If you see from the US India perspective, there is hardly step has been taken to resolve this particular issue. So that's why it is there is unpredictable trade and investment environment. So that is also leading to this. Also, policy uncertainty is there. So currently we are seeing how the Trump shown the uncertainty when it comes to the policy, and also when it comes to Indian perspective, India more or less they focus on the export market, export promotion. They give the subsidy for the exporters rather than focusing on the domestic capacity building or the working on the this back end issues. So that's why there is policy uncertainty and the pro export policies, and also the over dependence on the external tariff policy. So this is the one more reason. That's because of the investments that supposed to come India that getting dropped. So next is the what is going to make impact on Indian economy. Obviously, there will be investment slowdown. So nearly 2 lakh crore investment worth of foreign project halted. So what will happen? The major blow will to the FDI inflow, and how it again make the condition worse, because if there is no FDI, what will happen? No FDI is there means there will be less forex for India, and less forex in the sense there would be volatility in exchange rate. So this is again one more issue that we are going to face. Second, if we see the job losses, if we see the where this manufacturing, this particularly apply comes mostly in manufacturing sector, service sector. They are the primary employer when non-agriculture employers. So these sectors going to be impacted, and it will again the impact the efforts to formalize Indian economy. Also, the growth concern. If adequate FDI is not coming, there is the domestic limit where the companies or the businesses can generate the credit or the investment from the from the home itself. So what will happen if there will be less production, and less production will directly link to the this growth. So that is one issue. Also, investor confidence. So the present investor from who are want to invest in the home itself, from the home, so their confidence also will be shattered. Also, it will also the blow to the big ticket initiative. So what are the big ticket initiative presently? We have big ticket initiative. We have the Make in India. We have developed country or Viksit Bharat by 2047. Then we have 5 trillion economy. We want to become 5 trillion economy, 5 ton economy. So these all the big tickets will be receive the blow because of the reduce the foreign direct investment and the pulling by the foreign companies. So to avoid this, what we need to do? We need to focus on the faster conclusion of trade deals. Okay, trade deals. What are the trade deals? Now the presently we need to conclude a trade deal with USA. Also, there are free trade agreements in talk with European Union. Okay, so these are our major markets where we need to focus on and conclude the free trade agreement. So there would be less uncertainty when it comes to the export, and also the FDI norms. Also, we need to stable, transparent tariff policies. So why the primary USA imposing the tariffs on India? Because of the they consider we are imposing higher tariffs on their exports. So we need to have this stable, transparent, and the well determined tariff policy to avoid this kind of issues. Then also we need to boost domestic ease of doing business. So how we will boost the ease of domestic ease of doing business? Through the faster clearance, okay, so reforming land acquisition laws, or also the labor laws, IPR regime. So we need to bring reforms here so that there would be boost in domestic ease of doing business. Also we need to diversify FDI sources. Primarily we see where our FDI comes, that is primarily from the if you give the Singapore, then it will be more majorly from the West and the USA. So we need to focus more on the Gulf countries. Also as well as Asian countries. Also we need to take the benefits of China plus one policy. So on these aspects we need to focus to increase the FDI or diversify FDI sources. Also we need to strengthen the domestic manufacturing ecosystem. So we'll no longer dependent on the foreign direct investment, or the will no longer on the use to the foreign this foreign uncertainty, or the international uncertainty. So for that we need to boost the our domestic manufacturing ecosystem, so we can export more and earn the forex, and we can bring the stability in exchange rate. So this is all you need to know about this particular article. Next article is about the it's about the organ donation. So if you want to know the context, what has happened, the Madras High Court, it set aside an order passed by authorization committee. It is responsible for regulating organ donation. So previously what happened, this authorization committee, it has given the verdict that the two friends were there from the Tamil Nadu state. So they failed to prove that they are close, they know each other from the long time, and for that they said this authorization committee has not given permission to for the organ donation. That may become the case. Now we'll see what is exactly the legal provisions for that to donate organ, because this is the recurring issues in the news, and so UPSC might ask question. Also there is a ethical angle related to it, that also we are going to see. So when it comes to this particular organ donation, there is a law called the Transplantation of Human Organ and Tissue Act, which brought in 1994. It is popularly known as TOTA Act. So this act enacted to regulate organ donation and to prevent illegal organ trade. So primary focus was prevent the illegal organ trade. So also this law governs the transplantation of human organ and tissues in India, including donation of organ after death. So if we want to donate organs after death, still that will be regulated under this particular TOTA Act. Also when it comes to the donor and recipient, so there is also certain rules or certain provision under this act. So transplant can either from the pool of organ of deceased person donated by their relatives. Okay, so if person is deceased, so they need to have the permission of their relatives, or from the living person. Okay, some living person also can donate, but if when it comes to the deceased person, there need to be permission of their relatives, and when living person is below the age of 18, then need to permission of his parents, his or her parents. And in most of the case, this act allows the living donation from the close relatives. So there is this catch here, they allow the donation from the only close relative. Who comes under close relative? Parents, siblings, children, spouse, grandparents, and grandchildren. So these are the close relatives or the blood relatives considered under this act. So from there only, from these peoples only, will this particular act permits to donate and receive organs. Also, if you want to take organ donation from the distant relatives or foreigners, that also regulated under this procedure. So so altruistic donations, okay, from the distant relatives, in-laws, or long-term friends are allowed after additional scrutiny to ensure there is no financial exchange. Okay, so many times you will be thinking that you can sell your friends organs and become rich, but there will be scrutiny. So be aware, don't below, don't focus on this kind of plan, because you will get caught by the authorization committee again. Also, when that time also, the organ donors and recipients, they will be interviewed. If the donors or the recipient, they are distant relative or the foreigners. Okay, so that time they will be interviewed. So next provision is there, when if you donation from the unrelated person. So mostly it is talking about the friends. So that time we need to provide the documentary or photographic evidences. Okay, and this is the actual case why this news came into news. They were the friends and they failed to prove that they were long-term friends or the unrelated person. So they need to have the documentary and photographic evidences. Also, it is examined by the external committee to prevent illegal dealing. So this provision brought to prevent illegal dealing, but not a genuine one. So also there is provision of fines and punishment. Okay, in case there is illegal donation, organ donation, or the in case someone is donating for the financial action, then that time there are provision of jail term up to 10 years and fine up to 1 crore rupees. So be aware of this. Also, there is institutional setup that brought under this particular act. They have brought the National Organ Tissue Transplant Organization. So this NOTO is the national level organization under the Director General of Health Service under the Ministry of Health and Family Welfare. So this is the national level apex organization which is responsible to regulate the organ donation under this particular act. Also, there is authorization committee, and this authorization committee established under TOTA rules in 2014, and this will be ensure there is no commercial transaction involved when it comes to the organ donation. Also, this particular authorization committee, it will oversees and approves the organ transplant procedure involving donors and recipients who are not near relatives. So if you see the news, what is the news? The High Court set aside order passed by authorization committee. Why it is passed? Under this provision, it give the decision, because these two people who was the donor and recipient, they were not relatives. Okay, so under this particular rules, this authorization committee has got that particular power. So now when it comes to the men's perspective, what we need to see, what is the ethical dimensions involved here. So first is the ethical, this organ donation is act of altruism. Okay, so if somebody is need, you can save the somebody's life, then it will be considered altruism. There is a fundamental difference between altruism and philanthropy. So altruism will not expect anything in a return. Okay, so if you are donating organ for the financial action, then it is not a act of altruism. The act of altruism when you will not expect anything in return. Also, it is this act given the ethical safeguard, because it is the reducing the illegal trade in organs. Also, it is reducing the mafia raj in the organ donation, organ transplantation, all these things. Also, it is discouraging the financial exchange, organ donation for the financial exchange. So there would be exploitation of the poor or illiterate people who are not able to fulfill their needs, or there might be people who can exploit these needy people. So there would be need of ethical safeguard, and this particular act brought this ethical safeguard. But also this law has brought conflict of the humanity. So this law is in conflict with humanity. So because if somebody is in need, and if I want to donate my organ, so I can't donate because of the provision under this act. So we need to give the documentary and photographic evidences to prove that we know each other from the long time. It's in that case, if I don't know about the particular person, then I can't give. So if I want to do something from the humanity perspective, then this act is disallowing me. So there is a conflict between this law and humanity. Also, it neglects the affectional relations, because even some friends are there. So there I have many friends who I know from the childhood, but if they ask me to prove on the photographic or documentary evidences, I might not be able to. But what is happening in that case? They will reject the organ donation from that person. So it is neglecting the affectional relations. Okay, so I'm ready to give the give organ donation to my close friends whom I know from my childhood, but I'm not able to prove that we are the friends from the long time. So they are neglecting the affectional relation with that person. That is the one ethical concern related to this one. So this is all you need to know about this particular article. The next article is about the India's recent maritime reform and course correction. So what this came in because the just government has the Rajya Sabha has passed one bill called Indian Port Bill to 2024, and this bill brought to replace the Indian Port Act. So we'll just see the what were the key provision of Indian Ports Act, because to reform this particular act, this bill has brought this Indian Ports Bill. So when it comes to the Indian Port Act, this particular bill brought in 1908 during the colonial time. And what are the major provisions if you ask? There are the provisions related to classification jurisdiction. So major and minor ports, the current criteria we see the major classification of ports in the major and minor ports is done under this particular act. And also they have fixed jurisdiction of central and state government. When it comes to the major port, this comes under the jurisdiction of Union government, and minor ports comes under jurisdiction of the state governments. These all things done under this act. Also, it given the has given the rules for the lighthouse, buoys, beacons. Also, it is ensured the safe navigation of vessel within the port water. So, it is given the certain guidelines and standard for unloading, loading, unloading. All these things as given in this particular act. Also, it is given the appointment of port officials and their power. So, these were the major provision. Now, the why this particular act become outdated and why there is need to bring this particular Indian Port Bill. So, this act become outdated because does not cover containerization, offshore energy, ship finance, and globalized logistics. So, if you see, this particular act came in the colonial time. Now, what is the current development is happening? So, there is the provision where we are want to generate the offshore energy. We are also focusing on the ship finances and also the globalized logistic, that we are bringing the logistic policy. These all aspects are not covered in this particular act. Also, there is when it comes to regulatory framework, it is fragmented because the minor ports directly comes under state government, and different states have different rules for the this non-major or the minor ports. So there is the regulatory fragmentation. Also, it couldn't address the private sector participation. So and currently where we are focusing PPP partnerships in ports, also the environmental concern, these are all neglected in this particular act in which brought in 1908. Also, it has the weak enforcement powers for the disputes, safety standards, international convention, all these things. Because many of the international convention came after World War II, and these are not covered in this particular act. So these are the reason behind the bringing the new bill. So what is particularly has brought in this particular bill, if you ask? So what is the brought? There has been national level policy framework. Okay. So they have established one body. They are aimed to establish one body, that is Maritime State Development Council. Okay. This particular body will replace the all center state division. So this will be it will have the sole authority to govern the all ports in India. Also, it will have the standardized port planning regulation aligned with the global practice that is given by the International Maritime Organization UN clause. So the whatever the standards and planning are there, that will be on the with the best practice of that given by the IMO or UN clause. Also, it is expanded scope. How it expanded scope? Because it has included PPP projects, private port operators. Also, it is considering environmental safety standard which were not in 1908 Act. Also, it is establishing modern dispute resolution system. So these all the new changes has brought in this act. Also, it is given the provision for registration of all kind of vessels. So earlier only there was the need for registration of large shipping vessels. Now the small all kinds of vessels need to register. Also, when it comes to the policy integration, it is brought to integrate our flagship policy of maritime domain like Sagarmala, Gati Shakti to ensure national level coordination. So these are the major changes brought under this particular bill, or brought by the particular bill. Now there are certain concerns when it comes to the bill. What are the concerns? Because it is disturbing the federal balance and it is leading to over centralization. Because this particular body, that is Maritime State Development Council, it will be chaired by the union minister. Okay, and it will give the policy making powers and ability to issue binding central guidelines to the state. So it will definitely, it is going to hamper the federal balance. Also, when it comes to the dispute resolution, judicial reviews, there are certain cases, certain cases which will be given to the internal committee instead of the judiciary, and it is also effectively reduce the power of the civil courts. So that is the one major aspect, major concern when it comes to the this particular act. Also, when it comes to the ownership and registration, it is increasing compliance burden on the small craft and the coastal livelihood, because now the all kinds of ship need to register. So this will increase the compliance burden on the this particularly coastal the fishermen's, okay, all the small crafts operating in the seashore. Also, it is given the discretionary power to Director General of Shipping, because it has given the broad discretion to license foreign vessels. And the wake ground, what would be wake ground? We already know there would be wake ground based on the national security. So these kinds of grounds would be there where the Director General of Shipping can reject to give the license to foreign vessels. So this is the discretionary power given. And where it is going to impact more, it is going to impact the state maritime department or ports authorities had the power to regulate the minor ports. Now they will not have the powers. Also, it will impact the small coastal operators, okay, which are operating in small scale. They are going to bear that increased compliance burden. Also, the registration hurdles, all these things are going to face now. Also, the fishermen, also major impact will be on foreign players. Now we are focusing more on to bringing the foreign investment. And this particular bill, what is leading? It is given the discretionary power to Director General of Shipping to cancel the license of foreign vessels. This is definitely going to impact the foreign vessel operating in India. So this is the all you need to know about this particular article. Okay, this is the still the bill. When the president will get assent, there will be again the debate on this bill. Okay, that when it become act. So that time again we will see in this in detail. So next is about the should reservation exceed the 50% cap. Okay, this article also I have discussed in I guess in Monday's session, where we have seen the what are the major cases, what are the acts, and why there is demand. Okay, there was the demand in Maharashtra for the Marathas, and also in Telangana. Telangana government wants to increase the OBC reservation to 42%. Also from the yesterday in Bihar's leader of opposition, he also increase. He demanded to increase the eliminate the 50% ceiling. So when it comes to this, there is this article which analyzing this debate. Does the equality under Article 1516 allow expansion of reservation beyond 50%? So before going to debate, seeing the debate, briefly see what are the constitutional provisions. Constitutional provisions are the Article 15.4 and 15.5. It gives the special provision for the educational advancement, the socially and educationally backward classes, scheduled classes, and scheduled tribes. So for them, it has given the special provision when it comes to the educational advancement. And this particular provision brought under the first Constitutional Amendment Act 1951. Okay. So second article, constitutional article is there, provision is there. Article 16.4, it gives the reservation in the public employment for the backward classes which are inadequately represented. So this is one more constitutional representation. Also, there is the directive principle for the state also, which obliges the state to promote the educational and economical interest of the weaker section. And in weaker section, most of the time, scheduled caste, scheduled tribes, and other backward caste comes. Okay, primarily we'll confine to here because of our discussion related to reservation. So this section comes under, and Constitution has obliged the state to promote their economical and the educational interest. So this is all the constitutional provision. Now just briefly we'll see what is the uh, development of this particular reservation provision. This all started with the first Constitutional Amendment Act 1951, where the government has inserted these two articles, that Article 15.4 and Article 15.5. So here it has given the reservation for the educational reservation for the socially economically backward classes, scheduled caste, and scheduled tribes. Then next development came in the 1980, when the government has established Mandal Commission. And subsequently, this Mandal Commission is recommended 27% reservation for the OBC. And in future, in 1989, this reservation accepted. And the next, the legendary case comes in 1992, where we have seen the Indira Sawhney case. So under this case, Indira Sawhney case, Supreme Court has checked the validity of this reservation for the OBC, 27% reservation of the OBC, and it is given that the 50%, the present ceiling we see 50% ceiling, this came under this particular case, that is Indira Sawhney case. So it is imposed 50% ceiling. And while analyzing this particular reservation given to OBC, it has given the two terms. That is, one is the formal equality. So in formal equality, it says that this formal equality says that they all should be equal irrespective of their present stand. That is, irrespective of their caste, their economical position, their social background, okay, or their educational background, anything. Everything should be equal under formal equality. And when the Supreme Court upheld this 27% reservation for OBC, it has given under the substantial equality. What comes under the substantial equality? It says that substantial equality. It says that there should be adequate steps need to be taken to uplift the backwards. Okay, so there should be equal when the everyone position at the same place. So that is the one more aspect brought under the Indira Sawhney case. So next, reservation related development came in the 2005. After this, where the government has given this extended 27% OBC reservation to the educational institute, or primarily government educational institute. This is under the 93rd Constitutional Amendment Act. After that, again the significant development came in 2019, where the government has brought 103rd Constitutional Amendment Act, where it has given 10% reservation to the EWS. So this is the brief background of the reservation, how the reservation implemented in India. So now we'll focus on this particular article, what this particular article is saying. So there are the two types of argument when it comes to the eliminating this 50% ceiling. So first article, first opinion, that is arguments in favor, it talks about the Ambedkar himself, our founding father, the father of the Indian Constitution, Dr. B.R. Ambedkar, himself never fixed the rigid limit. So whatever the rigid limit, that 50% ceiling brought by the Supreme Court, so there should be scope for the equality. So is Dr. B.R. Ambedkar's focus of the equality or the equity. So it can be brought from the any mean. So the argument which is given in favor, they focus on this particular aspect. So they consider that by bridging the 50% ceiling, the equality can be brought. Second is the growing population of disadvantaged group. So 50% limit is now inadequate. If you see the data, there is many claims that the nearly 63% population of India, it comes under the OBC. It is other backward classes. So 50% reservation to 63% population, 27% reservation to 63% population is the inadequate. And when it comes to the EWS reservation, it is claimed that there are hardly 7 to 8% population which comes into upper caste, and they have the reservation of 10% benefit. So there is the conflict when it comes to EWS and the OBC reservation. Also, if you see the data, particularly given by the Rohini Commission, the reservation benefit are concentrated within the dominant OBC subcaste. So whatever the 97% OBC quota benefits are there, okay, that is captured by the few dominant subcaste under the OBC. So that is the one more issue. That's why there is argument to bridge that 50% ceiling. Also, it focus on the rising inequality, empirical data that showed underrepresentation continues requiring expansion. If you see the economic inequality, poverty, there is disproportionate presentation of the particularly backward class or caste. Okay, so that's why there is rising economical inequality. Again, though when it comes to social equality, there is the instances where discrimination happens. So these are all the arguments given to support this breach 50 violation of 50% ceiling. Also, if we see the vacancy, there is large backlog of the reserved post. Okay, so this there is argument to transfer this post to the OBC category and fill this post. So this is the one more argument given under this particular article. Also, when it comes to the there are many people who supports this 50% ceiling, because when those just I was discussing with that time I told that Indira Soni case, it brought the 50% ceiling considering Article 14, that is equality before law. So how equality before law? Because says that there should be equality between the unreserved and reserved person. So that's why that brought the 50% ceiling. And many opinion which counters this breach of the 50% ceiling, they support this opinion. So why it is support? Because the breach of 50%, if there is no 50% ceiling, then it will violate the formal equality and the merit. So if reservation goes beyond 50%, it goes beyond 80, 90%, what will happen? It will breach the formal equality. There will be the substantial equality, or what we are talking, it will be breach the formal equality and the merit will be neglected. Also, it will weaken the efficiency of administration. So Article 355, which gives the reservation for the certain classes, it says that it should be par with the administrative efficiency. And if you are bringing the for considering political through the political consideration, if you are bringing the more than 50% reservation, what will ultimately happen? It will weaken the administrative efficiency. Also, it will open floodgates to politically motivated demands for the quotas. Yes, again, this is the cycle. Previously, there was the demand for the OBC reservation that they got. Then there was the demand for the EWS reservation that also get fulfilled. So this will be cycle will be set. So it will be this cycle will be continue. So that will happen if you consider this demand. Also, there will be risk of dilution of opportunity for general category and EWS. So if the reservation goes beyond the 90%, 70, 80%, there are the meritorious candidate from the general category or EWS category, they will be in disadvantaged position. So by just bringing the equality, what we are doing, we are making the system unequal for the other people. Also, it will balancing equity with the efficiency. So there is need to reconcile this affirmative action with the constitutional guarantee of equality. So why this particular reservation given? To ensure the affirmative action, and there is this affirmative action need to guarantee constitutional equality, nothing but the equality of law, this equality before the law. So the both affirmative action and constitutional equality should be balanced. Also, now we have seen the arguments in favor and arguments against it. So now we need to see the what are the way forward, or from where we can bring the middle path to resolve this issue. The first is that is popularly everyone use this argument. There need to be subcategorization within the OBC or also the SC, ST. So the quotas to given to the unbenefited the categories or the castes which are not benefited from this OBC, SC, ST reservation, they will get more benefit. So there need to be subcategorization. Also, there is need of empirical data. Okay, empirical data driven approach. So when it comes to the political reservation under the in the local self government, Supreme Court mandated the need of the empirical data. Same applies to the this socially and educational reservation. There need of empirical data, and based on that, the reservation can be given. Also, there is need of periodical review. So why need periodical review? Whether the efficiency that or the this functioning, the reservation given is whether functioning properly or not. So for that, we need to bring this three initiative or to work on the three aspect where the ultimate benefits of reservation is to the most backwards, and the what is the spirit of the constitution that will be upheld. Why our founding fathers has given the provision of reservation that will be respected. So this is all you need to know about this article, and this is the opinion of author, and I have added some few opinion and directly used for the mains examination. So with this, we are finishing the discussion. Tomorrow I will come with a few more articles in tomorrow's paper, where we will discuss it from the mains and as well as from prelims. Thank you very much.